Parents, do your job or we will do ours.
Oh, man. I mean, that is one heavy threat to drop on a community.
It really is, but it's becoming a harsh reality right now in Washington, D.C. So let's get you caught up on the news, because this is wild.
Yeah, definitely.
Right now, U.S. Attorney Jeanine Pirro is launching a massive, aggressive crackdown on what locals are calling teen takeovers.
Right, the flash mobs.
Exactly. We're talking about these massive crowds of teenagers sweeping through neighborhoods like the Navy Yard and just causing absolute chaos. I mean, fights, robberies, smashed storefronts.
It's been all over the news. And Mayor Muriel Bowser, she tried slapping an 11 p.m. curfew on juveniles, right?
She did, yeah. But that completely failed to stop the crowds. So now prosecutors are pivoting to a totally different tactic. They aren't just hunting down the teenagers anymore.
They're going after the parents.
Yes, they are directly targeting the parents. Under D.C. Code 22811, if you drop your kid off or, if you simply let them skip school and they end up joining one of these mobs, you cross a major legal line.
It's not just a warning anymore.
Not at all. Parents are now facing steep fines, mandatory court-ordered parenting classes, and up to 6 months in jail.
6 months. I mean, the justice system is essentially redefining who takes the blame when a teenager breaks the law.
Which brings us to the core of our deep dive today. We're pulling together a pretty hefty stack of sources for you. We've got a DOJ press release, a 50-state legal breakdown from a major law firm, some conservative commentary from Red State, and a comprehensive university law review article.
Got a lot of ground to cover.
It is. But our mission here is to figure out what actually happens when the law decides that simply raising a child makes you financially and criminally responsible for their worst decisions.
Right. The ultimate liability.
Exactly. So let's start with this D.C. situation.
Yeah.
The U.S. attorney steps in with the threat of jail time. But how do they actually prove a parent is responsible for a random flash mob?
Well, it comes down to a very specific and honestly very slippery legal standard.
Okay, how so?
So Pirro's telling prosecutors they don't actually have to prove a parent actively encouraged their teenager to go riot. They only have to prove that the parent, quote, knew or should have known their child was participating.
Should have known. I mean, that feels like a trap.
It's definitely a wide net.
Mm-hmm.
In practice, it means, like, if you drop your teenager off at a spot famous for these takeovers and just drive away without checking on them, you're liable.
Oh.
Or if you ignore glaring signs that they're sneaking out your front door at midnight, the law says you failed your basic duty to supervise. You contributed to the delinquency of a minor.
And the U.S. Attorney's Office is making it crystal clear that they can and will charge parents, even if the local police never arrest the teenager.
Exactly. The teenager doesn't even need a record for the parent to catch a charge.
Now, that harsh standard is getting a lot of traction, especially in conservative circles. We looked at a piece from the news outlet Red State, written by Ward Clark.
Right, and he enthusiastically backs Pirro's crackdown.
He absolutely does. His core argument is financial. He points out that law-abiding taxpayers are currently subsidizing this chaos. When these flash mobs smash up a neighborhood, causing, millions in property damage, someone has to pay to fix it.
Yeah, the city ends up footing the bill.
Right. And Red State argues it shouldn't be the public.
And Clark actually pushes for penalties that go way beyond a 6-month jail sentence or a standard fine.
Oh, he goes straight for the livelihood. He argues that if a teenager is out rioting, the government should immediately cut off that family's public benefits, like SNAP or food stamps.
Which is drastic.
Yeah, and he even suggests garnishing the parents' paychecks for the rest of their lives to pay back the property damage.
I mean, you can see why that argument resonates with people who are just tired of seeing their local businesses destroyed.
Yeah.
Right. But we have to look at the mechanics of a punishment like that.
Right.
Cutting off food assistance or permanently draining a paycheck that bankrupts a family overnight.
And it ignores the practical, everyday reality of raising a human being. Think about the mechanics of being a parent for a second.
It's messy.
It is. Let's say your 16-year-old secretly takes your car keys while you are fast asleep in bed, and they go out and get a massive speeding ticket.
Happens all the time.
Right. Does garnishing a mother's paycheck for the rest of her life actually stop a determined teenager from climbing out a bedroom window? We act like parents have this magic remote control for their kids. But can anyone truly control a teenager 24 hours a day?
No, of course not. And that tension between deterrence and actual control is basically the biggest flaw in these laws. The threat of financial ruin doesn't suddenly give a parent the physical ability to restrain an uncontrollable kid.
Which makes you wonder how the rest of the country handles this. D.C. is making headlines right now, but if you live in Texas and your kid breaks a window, or if you live in Florida and they steal a car, what happens to you?
Well, if we crack open the 50-state breakdown from the law firm MWL, we find out that civil liability for parents is already the norm almost everywhere.
Really? Everywhere?
Yeah. In the legal world, they talk about torts, which is just a fancy word for civil wrongs, like vandalism, theft, or personal injury. If your kid commits a tort and they are still a minor living under your roof, you pay the bill.
I was actually looking through those state statutes, and I couldn't believe Hawaii.
Oh, Hawaii is fascinating.
They have the oldest parental responsibility law in the country, written all the way back in 1846, and there is no cap.
Zero cap.
Parents face unlimited financial liability for the damage their kids cause.
You really had to look at the historical context of 1846 to understand why that law even exists.
Yeah.
Back then, society was largely agrarian.
Lots of farming.
Right. Kids worked the family farm alongside their parents. Families rarely traveled far. So parents had absolute localized oversight of their children's daily movements.
So unlimited liability made logical sense to lawmakers at the time.
Exactly. But fast forward to today, and that law is still on the books in a world of smartphones, cars, and, instant communication.
Now, other states do try to put guardrails on it, right? Like California caps a parent's liability for a child's vandalism at $25,000.
Which is still a lot of money.
Huge amount. But if a parent lets a minor access a firearm and that minor hurts someone, the California limit jumps up. It hits $30,000 for one person, or $60,000 if multiple people are hurt.
And then Nevada goes even further to explain how courts view negligence with firearms.
What do they do?
In Nevada, if a parent knows their child has violent tendencies, but they still allow that child to access a gun, the parent faces unlimited financial liability.
Unlimited? Wow.
Yeah, the state uses the threat of total financial ruin as a deterrent. They are telling parents, you knew the specific risk, you ignored it, so you pay the whole bill.
And the timeline for that liability lasts longer than you think. Yeah. We always assume you're completely off the hook the second your kid blows out the candles on their 18th birthday.
That's the myth, yeah.
Yeah. But in Nebraska, parents are legally responsible until the child turns 19. And in Mississippi, you are liable until your kid turns 21.
21.
Right. Your child could be a junior in college, living in a dorm, and you are still legally paying for the window they broke.
I mean, that catches a lot of families entirely off guard. But paying for broken windows or stolen cars is really just the civil side.
Right.
The major shift sweeping the country right now is the move toward criminal responsibility. Over 40 states now allow prosecutors to file criminal charges against parents.
Which is a massive escalation. I know states like Michigan and Georgia are heavily utilizing these strict furnishing statutes.
Yes.
If you supply a weapon to a minor, or if you just fail to lock up a gun properly and your kid uses it recklessly, you aren't just writing a check to the victim anymore. You are going to a prison cell.
Before we dive fully into the criminal side, though, we have to address how families actually pay for these massive civil damages.
Good point.
Because if a teenager burns down a multi-million-dollar school gym, a normal family can't afford that out of pocket.
Right. So does your homeowner's insurance policy just step in and write a giant check?
That exact scenario has actually split courts across the country. It all comes down to how insurance law defines an, quote, intentional act.
Okay.
So in New Jersey, the courts have ruled that, yes, insurance must cover it. Their logic is that from the parent's perspective, the liability was completely unexpected, and people buy insurance specifically to protect against unexpected financial ruin.
Okay, that makes sense for the parent. But if a teenager intentionally strikes a match and burns down a building, insurance companies usually fight tooth and nail to avoid paying for an intentional crime.
Which is exactly how the Supreme Court of Ohio ruled. They declared that insurance does not cover intentional damage, even if the parent didn't plan it.
Oh, wow.
Yeah, the kid caused the fire on purpose, so the insurance company walks away, leaving the parents holding a multi-million-dollar bag.
See, paying out of pocket for property damage is devastating. But the legal stakes change entirely when the damage isn't just a burned-down gym. What happens when a teenager causes a mass casualty event?
This is where the American legal system is facing an unprecedented test.
Historically, victims of mass shootings spent years trying to find justice by suing deep pockets. They sued the manufacturers who made the guns.
Right.
They sued video game makers, arguing games like Call of Duty essentially trained the shooters. Families in Uvalde recently sued social media giants like Meta, claiming the platforms radicalized the teenagers.
They also went after property owners. After the horrific Las Vegas shooting, MGM Resorts paid an $800 million settlement because the shooter was able to stockpile an arsenal of weapons inside their hotel.
But the lawsuits against video games and social media companies constantly hit massive legal walls.
They do.
Judges consistently rule that a tech company in Silicon Valley is not directly responsible for a teenager pulling a trigger. The causal link is just too indirect. So when those avenues for justice closed, prosecutors and victims pivoted.
They started looking directly at the people who raised the shooter. Which brings us to the most terrifying new legal frontier for parents. The landmark case here happened in Michigan. In 2021, a 15-year-old killed 4 students at Oxford High School.
Right.
And in 2024, for the very first time in United States history, the parents of that school shooter were convicted of involuntary manslaughter.
They didn't pull the trigger, but they each received 10 to 15 years in state prison.
The prosecution built their entire case on the concept of gross negligence. The parents bought their teenager a 9mm handgun as an early Christmas present.
Which is just, yeah.
And they made this purchase despite receiving very clear documented warnings from the school regarding their son's rapidly declining mental health and violent drawings.
And we are seeing prosecutors use this exact playbook again right now. Following the 2024 Appalachia High School shooting in Georgia, the father of the 14-year-old shooter is facing murder and manslaughter charges.
That case is wild.
It is. Law enforcement had previously investigated the boy for making threats online. Despite knowing about that police investigation, the father still bought him a weapon as a holiday gift.
The legal standard has shifted radically. It's no longer just, you failed to lock up your gun. The new standard is, you actively enabled a murder.
It's like a chain reaction. To secure a manslaughter conviction, prosecutors have to prove the parent didn't just casually miss a red flag. They have to prove that the parent essentially handed their kid a book of matches while sitting back and watching the house burn down.
Right. The negligence must be glaring, obvious, and directly linked to the final act of violence.
But there is a grim irony in these cases that rarely gets discussed.
This introduces a massive layer of complexity, which is why the University Law Review article we examined raises a giant red flag about this entire legal trend.
Putting a grossly negligent parent in prison feels like justice. It satisfies a public demand for accountability. But the Law Review article dives deep into the systemic risks of writing these laws so broadly.
The author warns that when you criminalize parenting mistakes, you risk devastating marginalized communities. Historically, whenever parental responsibility laws are strictly enforced, Black mothers and low-income single mothers end up facing the absolute harshest scrutiny from the justice system.
The sources gave us 2 specific case studies to contrast how this actually plays out in American courtrooms. Let's look at the first one. Deja Taylor is a Black mother in Virginia. Her 6-year-old son managed to find her gun, brought it to his elementary school, and shot his teacher.
A total tragedy.
Yeah, and the federal government stepped in and prosecuted her heavily, not just for failing to secure the firearm, but by legally tying the incident to her marijuana use. She was sentenced to 21 months in federal prison.
Now, the article asks us to contrast her 21-month federal sentence with a case out of Grosse Pointe, Michigan, involving a white suburban mother named Elizabeth Pooley-Otague.
Okay, what happened there?
Her teenage son killed his friend in a horrific car crash. He was driving 105 miles per hour in a 25-mile-per-hour residential zone.
105 in a 25 zone. That's insane. And the details surrounding this Michigan case are wild. The mother knew he drove recklessly. She actually had a tracking app on his phone that showed he regularly drove over 100 miles per hour.
She knew about it.
She did. She sent him text messages telling him to slow down. But despite knowing all of this documented evidence, she still went out and bought him an even faster, more powerful vehicle.
And the parents of the victim begged the local prosecutors to file charges against the mother. They argued that buying a high-speed vehicle for a known reckless driver was the exact equivalent of handing him an assault rifle.
But the prosecutors completely declined to charge her. Their official reasoning given to the public, they stated, quote, "Parenting is hard."
Parenting is hard.
Yeah, they noted that she sent text messages trying to keep him on the right path, so her actions didn't rise to criminal negligence.
I mean, when you lay those two cases side by side, it exposes the gaping subjective holes in the legal system.
Definitely.
A Black mother gets nearly 2 years in federal prison for a tragic failure to secure a weapon from a 6-year-old. A white suburban mother faces 0 charges after knowingly buying a deadly high-speed vehicle for a wildly reckless teenager, all because prosecutors decided parenting is hard.
It's hard to hear.
It is. The massive risk is that these laws end up punishing parents based on systemic racial and economic biases rather than objective guilt.
It is a bitter pill to swallow, but the Law Review article introduces another heavy psychological and legal theory to explain why society perhaps shouldn't rush to throw parents in prison. It's a concept known as natural punishment.
A natural punishment is a fascinating theory. It argues that when a child commits a horrific, violent crime, the universe essentially delivers the ultimate penalty to the parent before the courts ever get involved.
So the parent is already destroyed.
Completely. The parent faces immense public hatred and shame. They're ostracized from their neighborhood and friends. They often face total financial ruin from the civil lawsuits we talked about earlier.
Yeah.
And most tragically, they lose their child forever, either to a life sentence in prison or to suicide.
The theory argues that piling criminal manslaughter charges on top of a destroyed family might satisfy the public's immediate thirst for revenge, but it fundamentally fails as a deterrent.
Exactly.
Because if losing your child isn't enough to make you secure your firearms, the threat of a 10-year prison sentence probably won't change your behavior either.
It attacks the psychology of deterrence. Criminalizing the parent doesn't fix the underlying mental health crisis of the teenager.
But I have to push back on that idea. Giving a parent a free pass from prison just because they're grieving feels like a massive disrespect to the victims who lost their lives.
It's a tough balance.
The Crumbleys might be deeply sad that their son is locked in a cell, but 4 other families have to spend their holidays visiting their children at a cemetery. A grieving parent doesn't magically erase dead victims.
No, they don't.
At what exact point does parenting is hard stop being a convenient shield for gross, deadly negligence?
You've hit on the exact tightrope prosecutors are trying to walk right now. They have to find the invisible line where a tragic, everyday parenting mistake ends and criminal, deadly neglect begins.
This whole debate circles around a massive contradiction in how we view families. We started on the streets of D.C., where prosecutors demand parents exert absolute control over their teenagers to prevent flash mobs.
Right.
We zoomed out to see states holding parents financially liable for millions in damages and charging them with manslaughter for missing the warning signs of a school shooter. We demand total authority from parents.
Why? We also know that teenagers are fundamentally wired to rebel, keep secrets, and push boundaries.
Which leaves you with a profound philosophical question to mull over.
Let's hear it.
If the law demands that a parent exert total, unbroken control over a teenager under the constant threat of prison and bankruptcy, under the threat of absolute financial ruin, at what exact age and in what exact moment does a teenager's mind truly become their own?
That's the real question.
Because if society is willing to blame the parent for absolutely everything, do we secretly believe that teenagers have no free will at all?
If the parent is the puppet master, the teenager is just the puppet.
And the courts are deciding who cuts the strings? Thank you for joining us on this deep dive. We'll catch you next time.